Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
Registering a trademark is a milestone, but it is not the end of the story. A registration can be challenged and, in some cases, erased entirely. These challenges fall under what lawyers call cancellation proceedings. Unlike oppositions, which happen during the application phase, invalidity and revocation take place after a mark is already on the register. So, what are the grounds for cancellation? They fall into two main categories: invalidity and revocation. Invalidity wipes a mark out from the beginning, as if it should never have been registered at all. The reasons are divided into absolute and relative grounds. Absolute grounds deal with flaws in the mark itself. A mark that lacks distinctiveness, that merely describes the product, or that has become generic can be invalidated. Marks that are misleading, offensive, or that misuse protected symbols, like state emblems, can also be struck down. Relative grounds, on the other hand, deal with conflicts against earlier rights. If the registered mark is identical or confusingly similar to a prior trademark, for the same or related goods, it can be canceled. Conflicts with copyrights, design rights, trade names, or geographical indications can also form the basis. And then there's bad faith, when an application was filed with dishonest intent, for example, to block a competitor or to exploit another brand's reputation. Revocation works differently. It deals with what happens after registration. The most common ground is non-use. If a trademark isn't genuinely used for several years, 5 in the EU, 3 in the US, it risks cancellation. A mark can also be revoked if it becomes generic, like aspirin or escalator, or if its use becomes misleading about quality or origin. In some cases, even failing to meet ownership requirements can trigger revocation. Procedurally, these cases are handled by trademark offices like the EUIPO, the German DPMA, or the US Trademark Trial and Appeal Board. They are administrative, cost-effective, and largely based on written arguments, though the evidentiary burden is high. Evidence of use, proof of confusion, or records of earlier rights are often decisive. Many jurisdictions even provide a cooling-off period, encouraging settlements through coexistence agreements or narrowed scopes of goods and services. The consequences are serious. A successful invalidity claim erases the mark retroactively from the start. Revocation usually takes effect from the date of the request or decision. Either way, the result is the loss of exclusivity, often with ripple effects across markets and licensing agreements. That's why continuous trademark monitoring is essential. By keeping watch over new filings, online platforms, and global marketplaces, businesses can act early, either through oppositions or cancellation. Today, AI-powered tools make this easier than ever, scanning vast data sets for visual, phonetic, or conceptual similarities and generating alerts in real time. But even with advanced technology, expert legal counsel remains critical for strategy, evidence gathering, and procedural execution. The takeaway is clear: trademark registration is only step one. True brand protection requires vigilance. Invalidity and revocation proceedings are powerful corrective tools, but the strongest brands are those that combine proactive monitoring, modern technology, and seasoned legal expertise to defend their identity over the long term.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.